Good morning, everyone. Hi, thanks for attending our speaker program this morning on how to save for the future with special needs trusts and ABLE accounts. I'm really happy that you're all here. This is actually our last speaker program of this series. We will be starting back up in the fall, so hopefully you can join us in the fall for some more programs on new and different topics. Just a couple of housekeeping items before we get started. I handed out a survey to each of you, so if at the end, if you all wouldn't mind just taking a minute to complete the survey. One side is for a family member, the other side is if you're a service provider. We're able to do these both speaker programs because of the grant we have from the United Way of Southwestern Pennsylvania. So we really like to get feedback from those in attendance. And please, if you have any topics that you think you're interested in hearing about for our next session, we'll start planning that, our next series of speaker programs probably in the next month or two. So please, if there's any topics you think you're interested in that we haven't touched on, please make note of that. As a reminder, all of our speaker programs are recorded and put on our website. So you can, if you have any questions after this program that weren't answered or that you thought you heard incorrectly, this will probably be on our website by the end of the day today. So please, take a look when you can. If everyone I hope everyone had a chance to sign in. If not, maybe at the end you can, just sign in. And if you're not on our newsletter list, we can certainly add you to our newsletter list. So just a couple things. We do have a large group online today, about 50 people listening online. And I will ask Jackie, our speaker, to repeat the question if any questions are coming from the audience. And certainly if anyone online has any questions, you can ask as well, and that will be relayed to us. There are bathrooms on the other side of this wall are the men's and women's restrooms. You can go out either door, and they're just you make a right out this door and a left out that door. There's coffee, bagels, and tea in the back, and some muffins, so please help yourself. And I think that's about it. So let's get this thing started. And I'd like to introduce, I'm really happy to have our staff attorney from Achieva Family Trust, Jackie Connell, here today to talk about how to save for the future with special needs trust and ABLE accounts. So thank you.
Good morning, everybody. As Patty said, my name is Jackie Connell. I'm the staff attorney here at Achieva Family Trust. What we're going to do today is sort of go through kind of three parts. We're going to talk about government benefits, sort of the importance of them, some of the income and asset limits of essential government benefits. Then we're going to talk about special needs trust and how to preserve eligibility for those benefits. And then we'll sort of wrap up talking about some other just sort of future planning things such as decision-making, power of attorney, guardianship. We'll touch on the ABLE account. I just ask that as we go through, if you have questions, please feel free to raise your hand. Sometimes it helps just with the flow of the presentation to just deal with your questions as they come. I'll say that for also the people online, so feel free to ask in the middle. If not, and you want to save maybe a specific situation about your particular case, so after the program, we can talk more in detail about that. So first, just a quick kind of history on Achieva Family Trust. The trust was established in 1998 as a result of legislation in 1993 that essentially provided for the creation of pooled trust and payback trust. The reason that Achieva Family Trust got involved is, and we'll talk about this a bit later, but for a pooled trust, you have to have a nonprofit corporate trustee as the trustee of the pooled trust. So it was really a call to action for Achieva to reach out to people that Achieva had been serving since the 50s to really meet this need for pooled trust. So again, it was really as a result of the need to have a trustee for a pooled trust, and we were the first in Pennsylvania to actually administer a pooled trust. Since 1998, though, we now serve as trustee for the three types of special needs trust, so pooled trust, payback trust, and third-party trust. We'll talk about each of those trusts in more detail as we go along, but it's important to note that we no longer are just a pooled trust company. We do serve as trustee for the other types of special needs trusts. What we currently do with regard to sort of special needs trust and future planning is we do provide no-cost consultations to family members, individuals with disabilities, support staff, attorneys, anyone who basically might have a situation where a special needs trust could be in play. I do that all the time. I'm meeting with families. I'm talking on the phone to evaluate a situation to determine, is a special needs trust appropriate in this situation? If so, what kind? And then sort of look at the options from there. So if anyone has any specific situation or documents they need reviewed, you can feel free to reach out to me. I do that at no charge. AFT currently has over 2,200 accounts. While we're primarily focused on beneficiaries in Pennsylvania, we do have beneficiaries in 12 other states. That's usually the result of maybe a beneficiary move or perhaps the person setting up the trust is from Pennsylvania, but the beneficiary lives out of state. So again, we are primarily in Pennsylvania, but we can serve as trustee for trusts for people who don't live in the state. And at this point, we have I think it's quite a bit more than $115 million under management at this point. So sort of just some questions that we'll try to address as we go along here. What would happen if I suddenly became unable to provide or care for a family member with a disability? Where will my family member live if I'm no longer able to live with the individual, or if I pass away? How will my family member function in the community without me? Who will look after my family members' finances? Who will make sure that my family members' health needs are met? And really, the most important question is, when should I start future planning? I mean, the fact that you're attending this program today means that in some way you've already considered future planning. You're here to learn more about it. It's never too early to start thinking about future planning. So again, you know, that question is sort of answered right away, and you being here, you are doing that. So the things that we'll consider, as I mentioned, we'll talk about government benefits. We'll look at means-tested government benefits versus entitlement benefits. And we'll talk about things like Social Security, Medicaid, and the different facets of each. We'll then talk about special needs trusts, the 3 types, and the various ways to set those up. And then finally, we'll hit on some future planning tools. As I mentioned, we'll talk about guardianship, powers of attorney, a letter of intent, and then we'll talk about our special needs planning guide that we provide to families. So we'll start with government benefits. So it's sort of important to distinguish between 2 types of government benefits. You've got your means-tested government benefits. We're talking about SSI, Supplemental Security Income, Medicaid, and then all the programs that are run through Medicaid, such as waiver, such as medical assistance for workers with disabilities. The important thing to note about these needs-based, means-tested benefits is that not only does the person receiving them have to have a qualifying disability, they also essentially have to be poor. I mean, that's sort of the most simple way to say it. There are very, very strict income and asset limits for an individual to qualify for these programs. So as we talk about them, we'll see where special needs trusts can come into play so that, you know, that money actually can be put aside to be used for the individual while also maintaining their eligibility for these benefits. We'll also hit on entitlements. So these are not means tested. In other words, at some point someone paid into these programs to qualify for them. So Social Security disability, for an example, and maybe the individual with the disability worked at some point. They had enough quarters. They paid into the program. Perhaps they're getting benefits off of a relative's record. So a parent retires and they can then have their adult disabled child collect Social Security disability. We'll talk about how that works a bit. And then Medicare, again, this is all these are programs that people have paid to, that they have contributed to. They're not basically funded through tax dollars, which the means-tested benefits are. So SSI, we'll talk about that first. SSI is a cash benefit that a qualifying individual can receive monthly. So in order to qualify for SSI, as I mentioned, you have to have a qualifying disability, so you have to be deemed disabled. That's usually defined by whether you have the ability to engage in substantial gainful employment. So if someone's unable to work, usually they're going to qualify as having the disability, but also they have to be low income. So there are some pretty strict income and asset limits. An SSI recipient cannot have more than $2,000 in his or her name. And that's sort of all bank accounts, retirement accounts, everything. $2,000 is the max. You are allowed to own a home and be on SSI, and you can own 1 vehicle. You cannot own a vacation home. You can't have multiple cars. The second home, the second vehicle will be considered an asset, and if it's more than $2,000 in value, the individual will not qualify. Income limits are also fairly strict. It's sort of it's really based upon, it's almost a dollar-for-dollar reduction. You make money and they reduce your SSI accordingly. So there are SSI recipients who work. It's usually fairly minimally, and their SSI will be reduced accordingly. So generally speaking, an SSI recipient is probably not going to be able to work at all, and if so, again, it's not substantial gainful employment.
If somebody is left a home in a will, and they own it, it's not an asset, but if they sell it, then all the proceeds become the asset.
Correct. So if an individual is left deeded a home as part of an estate, or a family member gives that individual a home, that's okay. But again, like you mentioned, if that needs to be sold at a later point, then the proceeds of the sale of that home will become an asset, and we'll talk about sort of some of the limitations of that depending on the age of the beneficiary, you know, what you can do with those proceeds if that in fact becomes the case. Extent of coverage, so the current SSI cap is $771 a month for an individual. So that is not a lot of money. Obviously, the government expects that you should be able to pay for your rent, utilities, and your food out of that $771. It's a little bit higher if you're married, but again, very, very low. Certainly not expected to live a high quality of life with $771 a month. So, and really important to note, if a person's receiving assistance, I just mentioned rent, utilities, and food. That is what SSI is meant to pay for. So if an individual is an SSI recipient and they're receiving help for those items, so a parent gives them money for rent or a special needs trust is paying their rent, that SSI will be reduced by up to a third. So if at any point the SSI is not being used strictly for those items and a person is receiving help for those items from an outside source, that SSI benefit, again, can be reduced by up to a third. So it's really important because when we talk about sort of distributions out of a special needs trust, we'll see how that can be very, very limiting for an individual who is on SSI. But really important thing about SSI is that if in Pennsylvania, if you're even receiving $1 of SSI, you automatically qualify for medical assistance. So for some people, it may not even be the cash benefit that's important. They might have a reduced amount or not the full amount, but again, they're automatically linked at that point to medical assistance. And for a lot of people, that is really the benefit that needs to be preserved because of medications, treatments, and things. Waiver, all of that is run through Medicaid. So into Medicaid, again, this is basically same requirements as SSI. You have to have a qualifying disability. Again, that will be looked at whether you can engage in substantial gainful employment, and you have to be low income. So again, go ahead.
I just have a quick question. Now, my son just turned 18, disabled, and was kind of new with this Social Security, but it's been a nightmare. And, I mean, I don't know what the problem is, but it's just been a nightmare. Now, when they're 18, does it, like, it doesn't base it on, like, he lives with me, obviously. It doesn't base it on my income, does it? Once they turn 18, is there individual benefits?
Yeah, so just to repeat the question for the online listeners, so she's asking that now that her child's turning 18, sort of whose income and asset is being used to determine the eligibility for SSI or Medicaid. At 18, it becomes the individual with the disability whose assets and income are considered. So they're no longer looking at household income. They're no longer looking at mom and dad's income or assets. They're looking strictly at the beneficiaries. However, if your son or daughter is living with you, they'll deem that as in-kind support and maintenance. So they assume that if a disabled individual is living with family, they're receiving some kind of benefit for that. So whether they're not having to pay full rent or they're getting food or utilities covered, so he or she would not be eligible for the full amount of SSI as long as he or she's living with you. But if there is a qualifying disability and he meets the asset, then again, it's a process. I mean, normally it's not uncommon to see people get denied at least the first time.
They didn't deny it. It's just that when we did get it, like a couple months later, it's just been a nightmare ever since. Like,
how so?
First of all, they gave me a reduced amount. Then I called them and they said I'm supposed to write a letter. And then I did that. Now they're investigating me. I mean, it's just crazy. It's one thing after another. And he's obviously disabled. And
yeah, well, the reduced amount is probably because he's living with you. I mean, again, they call that in-kind support and maintenance. They assume that whether it's the food, the utilities, or the rent, something is being subsidized by the caregiver that the person's living with. Therefore, he's not going to get that full $771. So if he were to move out of the home or live independently in some way, that amount would likely be restored unless you were still paying for his rent or paying for his food, then it could stay reduced.
now, does it make a difference? Like, he could never live alone. Actually, he's always going to have to live with me until I'm no longer able to take care of him. Does that make a difference?
It doesn't. I mean, again, if the in-kind, if they didn't, and they usually do, I mean, again, it's almost an assumption that if an individual is living with family, that means that they're receiving some kind of in-kind support and they won't be eligible for that full amount. So again, medical assistance, same asset limit as SSI, $2,000. You can own a home and a car. Greg?
Someone online is asking, do SNAP benefits reduce SSI?
So SNAP's kind of looked at differently. It's not counted against eligibility for SSI, but it's Also, SNAP benefits aren't sort of judged on the same platform as in terms of asset and income. SNAP's not really judged upon assets. It's more about the income that you have coming in, and that's the same with HUD housing. It's not based on assets necessarily. It's really based upon income. So no, getting SNAP benefits isn't going to count against you in terms of eligibility for SSI, but your eligibility for SNAP will depend on sort of the income that you have.
Does that also include SNAP?
Food stamps. Yeah.
That also includes like LIHEAP or any kind of...
Yeah, all of that stuff is judged a little differently. Those are more income-based rather than asset-based, but the existence of income, the existence of distributions from a trust, for example, can affect eligibility for SNAP, HUD housing. So we're not really going to get into HUD and SNAP. We could probably do an hour on those things in general today. We're going to just focus on really the cash and the medical piece, but the getting SNAP won't affect eligibility for SSI.
Because somebody lives in your home and they're getting an in-kind type thing, does that preclude Medicaid?
No, that is just for, so she asked that if someone's living at home, does that affect Medicaid in terms of eligibility in the way that it does for SSI? The answer is no to that. That's strictly sort of an SSI restriction. You can still be eligible for Medicaid if you're living at home with a family member. Again, it really just has to do with SSI being the cash benefit. They're not going to give you the full cash amount if they deem that you're getting cash from another source or, again, being basically supplemented by another source. Medicaid does not look at that. That's just an SSI. But the other thing that's important to note about Medicaid, again, it's not just necessarily prescription coverage or doctor's visits or hospitalization. There are a lot of programs that fall under Medicaid that are just vitally important for individuals with disabilities. One of the main is waiver services. So if you have a family member who lives in a group home or is receiving some kind of in-home support, having a caretaker come in several days a week, and that's being paid through Medicaid, it's likely being paid through a waiver. And for a lot of individuals, this is absolutely essential towards care through life, because if you have an individual in a group home, I mean, once you qualify for waiver, you're eligible for life. So, I mean, again, it's in services for waiver can be up to, $60,000, $70,000 a year being paid by the state. So,
I just have a quick question about Medicaid. Someone who told me in the doctor's office, all of a sudden, like I have employer insurance through my husband's employer. I work part-time, and my son has he's disabled, so he has Medicaid as secondary insurance. He turned 18, so we got the SSI, so it kind of went hand in hand, like you said. And all of a sudden, I'm getting paid co-pays. Is that the change that it makes once they turn 18? Because that's what the doctor's office said. Once they turn 18, Medicaid insurance changes, and they have to pay co-pays.
So it depends on sort of what insurance is primary and secondary. I mean, if he's 18, he'd be eligible to be on a parent's insurance until 26.
Yeah,
so
he's on ours as a primary.
Okay. As a secondary. And you're saying the Medicaid isn't covering the copays?
No, they're actually, I'm paying all kinds of copays now.
And
Since he turned 18, I'm getting copays. And when I questioned it, they said that when they turn 18, you have to pay something. Like he had an injury. He fell at school. And it's been a long road, so now we have to have him in PT, and they're charging
copays.
Like a charge.
Let's touch base afterwards about that, because, I mean, this is a pretty specific situation, so I'll probably want to get some more details. So,
that was just generally.
Yeah, and I'm not sure, to be honest with you. So let me get some details from you afterwards, and we can look into it. So, again, waiver services, providing residential, attendant care, respite, day programs, various therapies. The value of that, I mean, again, it's invaluable. It's even if, again, you're getting that $1 of SSI, the eligibility for waiver programs for individuals is just unbelievably invaluable as a long-term care service. So, again, it's vitally important to preserve eligibility for that benefit. Now, you'll see with waiver, we've got a little bit higher asset limits and income limits. You can have $8,000 in assets. You can make a little over $2,300 a month. So you do have a bit higher there. And same with medical assistance for workers with disabilities. That program was basically created in response to trying to encourage people who have disabilities who want to work to be able to do so. Because, again, essentially, with the low limits of straight Medicaid, it was really a disincentive to work. You couldn't really make any real money or have any real money and still be eligible for your Medicaid. So people would look at it and say, well, my Medicaid is much more important than me making a couple $100 a month. So they just wouldn't work. So MAUD, as it's called, Medical Assistance with Workers with Disabilities, attempts to address that. It has a little bit higher asset limits. You can have $10,000, and it has a higher income limit, a little over $2,500. So again, just an incentive for people with a disability who want to work to be able to do so. So those are kind of the primary cash and medical benefits that are, again, means-tested, needs-based, that special needs trusts are very good at helping with eligibility for. We'll talk about SSD now and Medicare. So as I mentioned previously, Social Security disability is not a means-tested government benefit. It is an entitlement benefit, and it's called that because someone at some point has paid into the program. This is not tax dollar money. It is money that someone who had previously worked paid into and now is available if the person is now disabled. So again, the disability standard is going to be judged the same as with SSI. If you're able to engage in gainful substantial employment, you likely will not be eligible for SSD. They'll look at the work history of the individual applying, and so again, it might be the case that someone became disabled later in life. Maybe they've worked for 20 years, they've paid into the program a long time. That's how the amount of the SSD monthly will be determined. And again, you do have some income limits there. It's about $1,200 for a non-blind disabled individual. You can make up to that in active income and still be eligible for SSD. And when I say active income, that means, again, actually going out in the community and working. If you're receiving some kind of dividend or some kind of interest or some kind of required minimum distribution from an IRA, that is not counted as active income in terms of eligibility for SSD. It's actual going out into the community and working. And again, the amount is going to be based on how much the person paid into the program, and probably you may be familiar that SSD is linked to Medicare. So, I mean, obviously Medicare is a health insurance that anyone over the age of 65 can qualify for if they paid for the program, but it's also linked to SSD because if an individual is collecting SSD for 2 years, they automatically become eligible for Medicare. So, again, it doesn't have to just be over 65. If you're collecting SSD and you're 35, once you've collected it for the 2 years, you'll be eligible for Medicare. So for people who maybe have never worked or never been able to work, that doesn't mean that they may not qualify at some point for SSD. There are some triggering events that can occur. So a parent, on the death of a parent, on the retirement of a parent, or on the point where a parent becomes disabled, if they have an adult disabled child that was disabled before the age of 22, that child may be able to collect off of the SSD that the parent paid into. So that's fairly significant because, again, as I said, you're capped with SSI at $771 a month. No one's going to receive over that. But SSD, if a parent's been paying into it and was, paid a lot into the program, that could really bump up the cash benefit that a disabled child receives. When that parent retires at 65, Social Security kind of does a reevaluation at that point and say that the person was an SSI recipient. They'll look and say, well, we've got a parent that's now retired. That child is now eligible to collect what they call adult disabled child benefits, and that could kick the person over into being an SSD recipient. Why is that important? Well, one, as I mentioned, that could increase the cash benefit significantly. You went maybe from collecting $771, now you might be eligible for $1,500 a month. So that's a big thing.
I'm wondering, do they get half the amount that the parent would have received?
If the parent is collecting as well, it will be reduced. If the parent is now collecting their retirement, it will be reduced to the amount. So, for example, we might have, some parents might continue to work beyond 65, so it won't trigger until there actually is a retirement. But yes, it will be sort of a percentage of the parent's SSD if the parent is also collecting at that point.
What if they just die? Would it be the whole amount?
Then it can be eligible for the whole amount. But if both are collecting off of the same record, it will be proportionate. So if the parent just retires or becomes disabled himself and that he needs to collect his own SSD, the child will still be eligible, but the amount would be reduced. But if the parent dies, then he'd be eligible for the full amount.
Does it replace the SSI or is it added?
It will. No, it will replace because you can. If you are eligible to receive more than the $771 of SSI, you're kicked off of SSI. There are people that say that you're eligible for $400 in SSD. SSI will still pay you up to the $371 to get you to that $771. But as soon as you're receiving SSD an amount more than the SSI max, you'll be kicked off of SSI, and you will then be eligible for just SSD. Yes, if you want to maintain that portion of the SSI.
Okay, that's my thought.
Yeah. Yeah, so if you're dual eligible and you're still receiving some SSI, then you have to meet all of those requirements to maintain that amount of SSI.
The retirement age in SF, if you retired at 62 versus 65.
It would probably increase the amount. It's sort of in the same way that if you retire at 62, you get a reduced amount. It would affect it in that way. Right. Did I see another hand somewhere?
Same question.
Oh, okay. Yeah, so the question was, if you retire at 62 versus 65, is it still in play? Yes, you can still have an adult child get survivor benefits, but it will likely be reduced in the same way that if you start collecting at 62, you receive less money than if you would start collecting at 65 or later. So again, Medicare, this is also an entitlement. You will become eligible to collect Medicare after you've been on SSD for at least 2 years. And so the thing with Medicare is this. I mean, if you're over 65 and you're already collecting Medicare, you'll realize some of the limitations of it. There are costs associated with Medicare. You usually have to buy some kind of gap coverage. You have to buy a Part D program to help you with prescription coverage. So Medicare is sort of limited in that way. There are still costs associated with it. So what's important to note for someone with a disability is that he or she may be eligible for Medicare, but Medicaid might still be critically important for that person, because not only can you can be dual eligible, you can have Medicare as a primary insurance, and you can have Medicaid as a secondary. So basically what Medicare is not paying for, Medicaid will pick up the gap coverage, the prescription coverage. So you might have an individual that's on SSD and qualified for Medicare, but that does not necessarily mean he or she will not be on Medicaid at some point or may not qualify for Medicaid. I get that question a lot. People will call, and an attorney might call me and say, well, my client's on SSD and Medicare. He doesn't need a special needs trust, right? Well, right, in the sense that if he's just on SSD and Medicare, he won't have to meet any eligibility, income, or asset limits. But what a lot of people don't realize sometimes, and even the beneficiary, him or herself, won't realize, is that they actually do have Medicaid as a gap coverage. So if you're not sure, you want to definitely get clear on that, because, again, people might see SSD and think, oh, this is an entitlement benefit. It doesn't matter. He can have as many assets as he wants. He can have a little bit of income. But, again, there is always that Medicaid component that might be present. And if Medicaid is in the picture, you are bound by the income and asset limits, the $2,000 in assets and the lower income limits. So it's important to kind of evaluate that when you're making a decision whether a special needs trust could be necessary. So any other questions about benefits? I mean, again, we could do hours on benefits alone, so we're kind of skimming the surface.
I have another question back to that, collecting on the parent disability. Does the child have to have been receiving SSI to get the parent disability since they were 22, or could they have had their disability at 22, which maybe you could prove with old medical records, but they weren't actually put on SSI because of applying like at 26?
So the question is, do you have to be on SSI before qualifying for the disabled adult child benefit? That's essentially what you're asking?
No, I'm asking if you have a person who did not get on SSI until 26, but were disabled at 22.
That doesn't matter.
Okay.
That does not matter. You don't have to ever have been on SSI. I mean, you could just be getting on SSD at age 50. But you have to be disabled before 22. That's the key point. It doesn't matter whether you collected SSI or not. So if you did collect SSI, for example, and then you're transitioned to the SSD, the good news with that is there's sort of a loophole that you'll stay qualified for Medicaid, which is a big deal. But you're not required to have had collected SSI at any point, as long as you were disabled before 22. And like you said, that will be demonstrated by medical records, school records, those types of things. That's what Social Security will use to evaluate whether you qualify.
How long does Social Security,
Well, they're not keeping records. It's really going to be the burden is on the individual or the family to come up with those records.
So they don't, once somebody has been receiving SSI, they just get rid of whatever qualifies them.
Well, and actually, I mean, no, if they have a record, so if the person is collecting SSI, they'll have a record that at some point there had been a determination made that the person was disabled. And actually, at that point, Social Security would prefer to shift individuals to SSD because, again, SSI is tax dollars. SSD is an entitlement that someone is paid into. So Social Security wants to get you off of SSI and onto SSD, absolutely, because, again, it's a tax program, the SSI. So they will be all for that. I mean, and that's why they sort of do their own determinations. And as I mentioned, a concern that I get a lot is, so an SSI recipient now becomes an SSD recipient. They went from getting $771 a month, now they're getting, say, $1,500 a month. Well, the issue, what it would appear to be an issue is that, wait a minute, Medicaid has a $1,300 a month income limit, and now this person's receiving $1,500 a month in SSD. So a lot of people panic and are like, I don't want the SSD, I want to go back to SSI, the Medicaid's what's important. But again, there is a loophole that will allow, if you had collected and qualified for SSI and were therefore eligible for Medicaid as a result of that, you can continue to be Medicaid eligible even if you end up on the SSD and that takes you over an income limit. And again, that is critically important because I get calls all the time, people panicking that their SSD is now putting them over the income limit for Medicaid, and they're just like, we cannot afford to lose the Medicaid. We'd rather not have the money, like take the money back. But again, there is a loophole that will allow you to continue to be eligible for Medicaid even if transferring over to SSD takes you above the income limit for medical assistance.
You were saying about the parents providing information. Is it more beneficial if you provide a lot of like the medical record, medical papers and stuff whenever you're getting Social Security, like for a disabled child?
I mean, you're going to have to, whether it's the adult disabled child benefit or SSI, I mean, at some point disability is going to have to be demonstrated. So a lot of times people will hire an attorney to assist with this process because the attorneys, what they'll do is they'll gather all that for you. They'll put it together in a nice packet and then do a presentation. And it can be well worth doing because if you're denied the first time because you haven't established a disability, appeals can take years to sort out. So it's really kind of important to get everything together at first and sort of put your best foot forward in terms of qualifying.
Yeah, because what I did was, the thing is I just got my guardianship. I had the hearing last Friday, so they were sending me a letter on something else. They wanted all this information, which I thought they already got. So I dug it up, all of it, copied it, and sent it along with all their papers. And I sent the guardianship too. Is that more beneficial to you when you give all that, provide all that? Because I thought they would have already thought that out.
Who would have thought that out?
Social Security. I would have thought that when they're determining whether your child's disabled, that they would have already contacted the genetic people to find out the diagnosis from when they were born.
I mean, they sort of don't have the ability to, did you sign releases and things? Because, I mean, they can't just sort of reach out and grab medical records. That's what I mean. I mean, and this, again, sometimes why attorneys get involved because they'll provide all those releases.
But I did it myself.
Yeah, and that's the thing. I mean, it really becomes if you can sign those releases and have Social Security do the work for you, but then you're relying on the quality of their work. How far did they dig? What did they come up with? What are they relying on? If you're sort of bringing the information to the table, you can at least be sure that they're getting everything. I mean,
that will make my case better.
And guardianship should help as well. I mean, if a guardianship was granted, it means that there's a substantial disability here. So.
I sent a copy of the signed.
But again, that's not going to mean that he's definitely going to get the full benefit. It's just, I mean, he's still probably going to be reduced because of the fact, yeah, correct.
Sorry to ask you, but kind of on back of what she's talking about. I'm wondering, the letter that they want from Social Security from her, I believe, based on my dealings with Social Security, is that they want you to charge rent to your son, and then he can pay you the rent.
Right.
You know an ABLE account, and you can put that rent in your ABLE account. I did that. And then they sent me a letter saying they were investigating. Well, they can investigate whenever they want, but I believe I was told by the person who investigates for my son, because I wasn't charging him rent, and when they figured that out, although they knew that from the initial application, she said to me, like, the exact sentence that I just said to you. You can take the rent and you can put it in his ABLE account. Whatever you do with the rent is your business.
Right.
So that way, that's what I've been doing, and it was based on her mouth, although she didn't write it down.
Yeah, that's a common tool, is to put a lease agreement in place between the parent and the child, because then it's basically you're basically laying out that the rent is meant to cover the utilities, the rent, and the food.
And what do you mean a lease agreement?
Yeah, it doesn't have to be that formal, but they want it to be in writing so that it's basically creating an obligation on the SSI recipient that he or she has to pay you X amount of dollars a month. And then SSI looks at that. It's almost like if he or she were living in the community and paying a landlord. So they just want to see that there is sort of an obligation on the SSI recipient's part to pay monthly, so that it sort of shows that arrangement in writing. So, I mean, that is something that people will commonly do as a way to try to get that full amount. And as mentioned, what you then choose to do with the rent is sort of up to you. But it's got to be paid regularly as an actual rent payment, not just sort of, oh, well, you know, in theory, I take a little bit of his SSI monthly and call it rent. It needs to be a little more formal than that. Greg, did you have your hand up back there?
I did, but I'm frozen, so I can't keep touching.
It's okay. Sorry, online listeners, we're having technical difficulties. All right, so any other questions on benefits before we move on to special needs trusts? Okay, so future planning. We're going to talk about how now leaving money to an individual with a disability, or that person coming into money in some way, maybe a personal injury settlement or something of that nature, how that can negatively impact someone's eligibility for benefits, and then what essentially we can do about it to preserve that eligibility. So we'll sort of start off by talking about two options that we want to avoid in terms of future planning. The first one would be disinheritance. That was sort of a common, I would say that's a little outdated, but it was a common scheme that if there was a family member that had a disability, say parents would just say, well, I'm not going to leave any money to that person. I'll leave money to my other kids, and I will count on my other kids to make sure that my disabled child has everything that he or she needs. So that's sort of not a good idea for a lot of reasons. I mean, let's just assume that, first of all, the other children have the best interest of the disabled child at heart, and that they're not going to mess around with the money or go on vacation with or whatever. Let's assume that. Even where best intentions exist, I mean, there are all kinds of life events that can happen to those non-disabled children that could put that money at risk. They could get divorced. They could get sued. They could have a judgment against them. Now, all of a sudden, the money that you had left to those non-disabled children with the intent that they would use it for your disabled child, it's now subject to all these liabilities, and it could be gone just like that. So we don't want to rely on disinheritance because it's not necessary, and I mean, again, that's with best intentions, and I mean, I'm sure we all have family members who we're not even sure that we could trust them to have best intentions, but we're going to avoid the disinheritance as the first option. The second thing that we will avoid is what we call an asset transfer. So Medicaid has what they call a 5-year look-back period, so that essentially when an individual is applying for Medicaid, they have to show basically if they transferred any money within the last 5 years of that application, and if they did, where did they transfer it to who, where did it go? And basically what they want to prevent is that on Monday you apply for Medicaid, on Tuesday you give all your money away to your neighbor, and then on Wednesday you're now all of a sudden poor enough that you can qualify for Medicaid. I mean, they want to avoid that. So you're not going to be able to just say, well, I have $100,000 today, but I need to apply for waivers, so I'm just going to give the $100,000 away. That will be deemed a transfer for less than fair market value, and Medicaid will impose a penalty period in which you won't be eligible for Medicaid for that time. So again, giving money away, gifting it away is not going to work in terms of qualifying for Medicaid, because when the application is done, you'll have to admit that, yes, I had money and I gave it away. You can spend it on yourself for your sole benefit, or you can put it into a special needs trust depending on your age, but you can't just give it away to qualify for Medicaid. So we're going to avoid those two options in terms of future planning and talk about what you can do. So again, we talked about this. If a person with a disability is on SSI or medical assistance or waiver, there are income and resource limits that apply. And then we're going to talk about now what can we do to protect benefits. So we'll talk about the 3 types of special needs trusts that I mentioned, third party, payback, and pooled. And then we'll also talk about ABLE accounts and how they can be used to protect eligibility. So everyone here is probably familiar with a last will and testament. This is a document that essentially dictates where your assets will go upon your death. I always recommend, for some families, wills are simple. When you die, everything goes to your spouse. When your spouse dies, it goes equally to your 3 kids, and it's really simple, and we don't need a lawyer to do that. We can just, do an online thing and no problem. That may be true for someone sort of with a fairly simple estate plan. But I always just recommend when you have an individual with a disability in the picture, it's not a do-it-yourself endeavor to do a will. There is very specific language that needs to go into wills to leave money into trust for this individual. And we'll talk about why that is essential to do, but I do not recommend you trying to do that on your own. And I really recommend that if you are hiring an attorney, you do hire one that has a background with special needs planning, because again, I review trusts all day, every day, and it would sort of blow your mind the mistakes that get made in these trusts and the unbelievable consequences that can have for someone on benefits. So again, if you are doing estate planning for an individual with a disability, I really recommend hiring an attorney and an attorney that has a background in this.
Do you have like a list of attorneys?
We do. Do we have this? Okay, so Patty has some here. She can get you one after. But yeah, we do have a recommended list of attorneys. It's on our website as well. It's broken up by geographic location, and it's just firms and attorneys that we've worked with over the years that we are confident know how to do estate planning for special needs individuals. And again, if the attorney isn't on the list, it doesn't necessarily mean that they can't do the planning. It's just sort of a start if you don't have anyone in mind. I always recommend, too, that if you do have a family attorney that you really want to use and maybe he or she is kind of like, oh, I'm not really done special needs planning before, I would be happy to talk with them and work with them. We do provide sample third-party trust language on our website, which can be a good start for the attorney, and I'd be willing to review it and make sure that it has all of the things that it needs.
I really have one done.
Okay.
But I our one for us, but I'm not sure after this.
Yeah, I can make a copy of that, and if you can leave me your phone number, I'll review it, and then we can talk about it. Because, yeah, I mean, again, it's not sort of just your run-of-the-mill last will and testament. There's specific language that needs to be incorporated, especially if you're creating a third-party special needs trust, and it's just really simple for that to go wrong. So it's important to work with someone that knows what they're doing, and again, I'd be happy to review any document that you have to see that it has the proper language, and it can always be redone. Okay. And then just a quick note, I mean, if you die without making a will, your assets will pass to your heirs at law, essentially, by the laws of intestacy. So again, for a lot of people, that result will be what they want. When you die, your money will go to your spouse, and then if you don't have a spouse, it goes to your kids. If you don't have kids, it goes to your parents, and so on and so forth. So a lot of people will be like, well, that's what I want, essentially. But the issue is that, and we'll talk about this more in detail, when you're leaving money outright to an individual with a disability, so you just put their name in your will, or you don't have a will and it just gets left outright to them without a trust, you're really subjecting that money that you're leaving to them to several sort of limitations and issues. So we, again, don't want to rely on the laws of intestacy. We don't want to leave money outright to an individual with a disability, because a third-party trust, which we'll talk about next, is the much preferred option in terms of leaving money to an individual with a disability. So special needs trusts generally, again, they're designed for beneficiaries who have a disability. That disability can be physical, it can be intellectual, it can be mental health, it can even be drug and alcohol. We have trusts for individuals that sort of span across the disability spectrum. Not all of our beneficiaries are on benefits at this point. Maybe they were at some point. Maybe there's anticipation that they might be someday. So it's sort of not a requirement that someone's already on a benefit. It's just there needs to be a disability in play. The monies in a special needs trust will be used to supplement the life of the individual with a disability, not supplant their government benefits. And that language is absolutely critical for a third-party trust. It has to say that the money is meant to supplement the life of the individual, not supplant their government benefits. So we don't want to use a special needs trust to pay for medications, to pay for things that Medicaid should be paying for. We have to be careful using it to pay for rent, to pay for utilities, to pay for food. because those type of payments could reduce the SSI that the person is eligible for. So there are very specific rules with regard to administering special needs trusts that the trustee of that trust must know in order to do it properly. So we'll talk about selecting a trustee a bit in a couple of slides. But some of the examples of supplement, I mean, it's more of what, the list of what we can do is far longer than what we can't. I mean, we can do recreation, entertainment, transportation, clothing, medical needs that aren't being paid for by an individual's benefits, again, vacations. It really is a long list of what we are able to do out of a special needs trust. We just have to be careful about, as I mentioned, the supplant. If an individual is on SSI and we're paying for rent, utilities, or food out of the special needs trust, that SSI amount can be reduced by up to a third. So we really try, when we're administering special needs trust, to not pay for those items for an SSI recipient for that reason. There are circumstances where if someone, say, has a very large trust and it doesn't make sense to sort of limit them to us not assisting with rent or food, we will allow that reduction to be taken because it might make sense. If someone has $1 million trust, there's sort of no point in having them live in poverty if we've got this special needs trust that can really make their quality of life better. So there are instances in which we will pay for rent, utilities, and food for an SSI recipient out of the trust. But again, for a lot of our people where they don't have a lot of money in their trust, we really try to maximize their government benefits, and we don't want to jeopardize them in any way. We do not do cash directly from a special needs trust, again, because these income and asset limits are so small. If you're giving cash to an individual on SSI, for example, that can lead to add up to $2,000 really quick in their bank account. So we just do not do cash directly from a special needs trust. We prefer to pay vendors directly. We have credit card programs. We can reimburse family members, but we're not going to write a check directly to the special needs trust beneficiary. We also do home purchases, accessibility renovations, vehicle modifications out of trust. I mean, again, there are big ticket items that can be paid for out of special needs trust that will not jeopardize an individual's benefits. So as I mentioned, 3 types of special needs trusts. We'll talk about third-party trusts first, and I mean, for purposes of this program, if you take nothing else away from this, I want everyone to understand sort of why third-party trusts are the preferred method when you're talking about future planning with regard to leaving money to an individual with a disability. We'll talk about payback and pooled trusts because they are important in terms of future planning, but again, I really want everyone here to take away the importance of, if you are creating an estate plan, incorporating a third-party trust into that estate plan. So trustee, as I mentioned, all special needs trusts have to have a trustee. At the very beginning I said that pooled trusts in particular have to have nonprofit corporate trustees. However, third-party trusts and payback trusts do not require that. You can have an individual serve as a trustee of a third-party trust or a payback trust. You can also have more than one trustee. You can have multiple individuals. You can have an individual and a corporation serve as trustee of a special needs trust. People sort of ask, you know, what makes sense, and I kind of like to give an example of that, where a co-trustee situation can really work. You might have a family member that you really want to be the trustee of a third-party special needs trust, but you might worry that that person, you know, has his or her own obligations, children, a job, maybe he or she lives out of state, maybe he or she just doesn't have a lot of time. So you don't necessarily want to saddle that person with the burden of being a trustee, but you do want them involved. So I always sort of recommend a co-trustee situation in that case, because what you can have is a corporate trustee that's basically doing the day-to-day administrative work. So cutting the checks, keeping the books, doing the investments, doing the tax return, being sort of the first line of, if the beneficiary wants something, they call the corporate trustee, not the individual. And that sort of takes the administrative burden off of the individual, but it allows the individual to stay involved. We can, as the corporate trustee, we would consult with the individual trustee. If, say, the beneficiary asked for a car, we would call the individual co-trustee and say, what do you think about that? Does that make sense? I mean, and then that way the individual co-trustee really can sort of have influence on how the trust is used, but they're not being saddled with all the responsibilities. I mean, as I mentioned, there are a lot of rules with regard to special needs trust administration, rules that the average person would have no reason to know or even want to know. So if you have a situation where you do have a family member that you want involved, consider a co-trustee situation so that, you're not burdening that person with all of the day-to-day tasks of special needs trust administration. And then, again, the monies in the special needs trust are going to be considered exempt. They won't count against the individual in terms of their eligibility. So you can have $100,000 in a special needs trust. That will not affect someone's eligibility for SSI. It won't affect someone's eligibility for Medicaid, so long as it's a properly drafted special needs trust. So first type of trust, and again, probably the most important one for this program, is the third-party trust. So it's called a third-party trust because the assets that are funding the trust belong to a third party. They never become assets belonging to the individual with a disability. So again, parents leaving money to their child, for example. It's third-party money. It's the parents' money that's funding the trust. The parents are the ones setting up the trust. So they're sort of acting as the grantor or the settlor of the trust, but they're also funding it. So again, the beneficiary not involved in this process at all. They're not acting as the grantor, they're not acting as the settlor, and they're not putting any money that is their money into this trust. It has to only be third-party money. So just an example of that, when we're talking about first-party money, what that would be. Someone is in a car accident and they get a personal injury settlement. That's first-party money. It's money that's paid directly to the individual. Same thing with inheritance. Someone has a will. They leave, $50,000 to Joe, who has a disability. That is Joe's money. It's first-party money. Third-party money never takes on the characteristic of first-party money. It remains always the money of the person that's making the contribution, and it goes directly into a special needs trust. So basically what you're looking at here is you have a will. Say you have 2 children. You want to leave half of your estate to each child. So child A has a disability, child B does not. You want to leave child A's share to a special needs trust for the benefit of child A, whereas you're going to leave child B's share just straight to child B. So you're not sort of putting the person's name, it's their special needs trust for their benefit. And that is a huge, huge distinction. And again, there's going to be a lot of language that's going to follow to set up that special needs trust in the will, but it is not being left directly to that person, it's being left to the trust directly. Does that sort of make sense?
Can you, now, in my case, I have a daughter, and we did the guardianship, and we made 2 people that were adults, my brother and his wife, as people until she turns 21. And then we have to turn charge. Now, when you do that third-party thing, would she be the person on there?
Are you talking about a special needs trust or guardianship? Big difference.
So, can I do the same setup for the special needs trust?
Yeah, I mean,
her in charge of the stuff, but yet have a third party.
Yeah, like I said, you can have an individual serve as the trustee of a third-party trust. That's perfectly fine. So if, right now, like you said, it's your brother and sister-in-law, whatever the case may be, and then your other daughter, when she turns 21, she would be. That's a perfectly fine,
You do the same type of setup in this type.
For the special needs trust?
Yeah.
Because I really want to make a distinction between guardianship and special needs trust. Because generally with guardianship, you can recommend potential successors, but the reality is a court has to actually put someone in place to do that. So you might say, if I'm not around, I want my sister to do it, and then when my other daughter turns 21, her to do it. But if that actually played out, a judge would have to formally put your daughter in as guardian. And if
I can actually make her.
Correct. I mean, you could have this in your document, in your will, that's setting it up that, at first your brother serving as trustee, when he dies, your daughter, or whatever the case may be. That's perfectly fine, and that can all be done within your will. But I really want to make a distinction between the guardianship, because it's quite different, and if we get to guardianship, we'll talk about that. But, yeah, the document itself will lay out who the trustee will be.
I just wonder, term supplemental needs trust sometimes used instead of special.
Yes, I mean, it's sort of interchangeably, exactly. Special needs trust, supplemental needs trust. It's just important to note that there are 3 different types of trust sort of under those headings and the difference between them. So a third-party trust is sort of a type of special needs trust or a type of supplemental needs trust. But, yeah, those terms can be used interchangeably. So a couple reasons that third-party trusts are preferable in terms of estate planning. Number one, probably the main reason for people is what happens to remainder funds when the beneficiary dies. So you've set up this third-party trust. It is paying for your disabled child for that person's lifetime, anything supplemental to their life. When that child passes away, though, where does the money go? So with a third-party trust, you will be able to dictate in the document where the money goes. So I want this money to be used for the benefit of my disabled child until his or her death, and then at his and her death, I would like the remaining funds to go to my other child, to go to my grandchildren, to go to my neighbor, to go to a charity of my choosing. You will have the ability to make that determination as a part of your third-party trust. And when we talk about payback trust and pooled trust, that is not the case. So you won't be able to preserve that legacy in the same way. So I would say that when we're talking about sort of one of the main reasons third-party trusts are preferable, it's because of that. There's no payback to Medicaid. There's no pooled trust retention. You, as the settlor of that trust, will decide where the money goes when your disabled child or disabled family member passes away. The other really big sort of important thing, and I'll show you some examples, there's no age limit to when someone can have a third-party special needs trust set up for them. They can be 90 and have a relative pass away and leave money to a third-party trust for their benefit. There is no age limit. We'll find with first-party trusts that that's not the case. So, again, no age limit, flexibility with regard to remainder funds really make, again, if you have the ability to do an estate plan with a third-party trust, it's absolutely the route you want to take. So the other two types of trusts, we'll talk about payback trust and pooled trust. So let's switch gears now. We're talking now about first-party money. So this is money that belongs to the individual with the disability. Again, I gave some examples of when that could happen. A person could come into some kind of settlement. A person could be left with a direct inheritance. Maybe there's a beneficiary on a life insurance policy, something of that nature, but regardless, the money is being paid directly to the individual with the disability, and therefore the money is considered first-party funds. The first option, if that were to happen, to place that money into a special needs trust to preserve eligibility for benefits would be a payback trust. This type of trust is going to be able to be established by the person with a disability, a parent, grandparent, legal guardian, or the court. So you kind of have a class of people who can act as the settlor on a payback trust. You will actually need to have a trust document drafted in this case, just like you would with a third-party trust. So an attorney will actually draft a special needs trust, a payback trust, and there are certain provisions that absolutely must be incorporated into the document. So again, this is not a do-it-yourself endeavor. You'd want to hire an attorney who has experience doing this because there are very important facets of these documents. The beneficiary of the payback trust has to be disabled as defined by the code, which is basically Social Security's definition of disability, which we discussed earlier. The beneficiary of a payback trust must be under the age of 65. The statute that allows the creation of payback trusts says that you cannot fund or put money into a payback trust for an individual once he or she reaches the age of 65. So anything prior to that, you can add money. As I mentioned, with the trustee, you can have an individual trustee or a corporate trustee or a combination of both. You have to have the document drafted by an attorney, and it must be approved by the Department of Human Services. So the attorney basically drafts the trust. They send it off to counsel for DHS to be reviewed. DHS has to approve it. If it's missing any terms or it's not suitable to their rules, then it needs to be redone. But it absolutely has to be approved by DHS before it is funded. So remaining funds for a payback trust. That I mentioned with a third-party trust, the person setting up the trust will dictate where the funds go at the passing of the beneficiary. That is not the case with a payback trust. So any remaining funds in a payback trust when the beneficiary passes away must first go to pay back the Department of Human Services for any Medicaid that person used during his or her life. So again, say that someone has been receiving waiver services for 40 years. That's likely a multi-million-dollar claim with the Department of Human Services. So you leave an inheritance to someone for $500,000. They use the money for their needs through their life. They die. There's $300,000 left. You request a statement of claim. It's multi-million dollars. That entire amount goes back to DHS. So you'll be able to say in the document if there was money left after that claim was paid where it would go. But the reality is for a lot of medical assistance recipients, there isn't going to be any money left over. It's just going to go back to the state. So go ahead.
Where does PA-ABLE fit under? What category?
Well, we'll do PA-ABLE in the next couple of slides. It kind of doesn't fall under either because we'll talk about it. I've got a few slides coming up on it. Did I see any other hands? Yes.
The CD and the primary trust was the spouse, but then secondary beneficiary was the special needs trust. Is that okay?
That is okay. That would
right to the special needs.
That would go to a third party. Absolutely. That's what you'd want to do with a situation like that, because again, the beneficiary is the third party special needs trust, not the individual with a disability. And so again, you will, with a payback trust, be able to say that after payback, if there's money left over, where it will go. So, people will often ask, well, when is an appropriate time to use a payback trust? We usually say when there is a large sum of money. So, maybe it's a several $100,000 inheritance or $1 million settlement or something of that nature. Perhaps the person isn't, heavily dependent on MA. There's a chance that money will actually be left over after payback. That's when we sort of recommend doing a payback trust, because we realize that families want to preserve legacy. They want to be able to leave money to their other family members or their charities of their choosing. But you just kind of have to make an evaluation at the time of setting up the trust, whether it makes sense to go through the whole payback trust process or use the second option, which would be a pooled trust. So a pooled trust is very similar to a payback trust in some of its requirements. The same class of people can act as the settlor on a pooled trust: the individual with a disability, a parent, grandparent, guardian, or the court. The beneficiary has to be disabled under the code. Again, that's Social Security's definition of disability. So far, payback trust and pool trust, same sort of standards, same class of people who can settle one, same disability standard being used for both. But here's where some of the differences start showing up. So age limit. As I mentioned with payback trust, you just absolutely cannot fund a payback trust for someone 65 or older. That's required by the code. The code does not have a same requirement for pool trust. You can establish a pool trust for someone over 65. There are just some limitations in doing so. As I mentioned before, Medicaid has a look-back period where if you transfer assets to someone for less than fair market value and then try to apply for Medicaid, they will not allow you to do so. So Pennsylvania Department of Human Services has deemed that any money transferred into a pooled trust by someone over the age of 65 is a transfer for less than fair market value. So essentially they deem it as just giving it away. You put it into a pooled trust, you're giving it away. Therefore, if someone is attempting to, say, qualify for nursing home care, there will be a penalty period generated if between the time of application and 5 years prior, any money was transferred either to a pooled trust or given away to someone. So it's not that we can't establish a pooled trust, we just have to be careful because, again, Medicaid will deem it a transfer for less than fair market value, which can affect an individual's ability to qualify for Medicaid. So
I have a question just based on, I'm not sure, I'm kind of backtracking. In our scenario, I have a 9-year-old son with disabilities, and we're looking to set up this special needs trust ASAP of the third party. But then so for like my parents and my husband's parents, in their wills, should they have it designated that if they're going to be leaving, that they specifically leave it to the third party?
yes.
And then it won't be taxed, it won't have anything to do still with all this.
Correct. So anyone who's considering leaving money to an individual with a disability, whether it's a parent, a sibling, a grandparent, wants to make sure that they have third-party special needs trust language in their will.
We need to set that up first in order for them to be able
There's a couple ways you can do it. I mean, they could set it up first, and then your document could refer to the trust that they've already set up. We also have instances where people have multiple third-party trusts. A good example of that would be parents who get divorced. Maybe at one point their estate plans were the same, so they set up a third-party trust for their disabled child, but then the parents get divorced. Now dad is remarried, he has children by someone else, mom is remarried and has children by someone else, and now all of a sudden that original document they had kind of doesn't work, because maybe at that point their remainder beneficiaries was just their common children, but now that mom and dad have different children and different spouses, they may not be able to use the same terms that they did before. So it's entirely possible that someone could have multiple third-party trusts. You can have a payback trust and a third-party trust. We see that often as well. But for your purposes, what you want to make sure is that if everybody's sort of in agreement on the terms of a trust document, all that money can funnel to the same one. But say your sister is like, yeah, I want to contribute to your child's third-party trust, but I don't want remainder funds to go to your other kids. I want them to go to my kids. She might have a separate document. So, I mean, it really just depends on, as an entire family, what you can agree on in terms of a document. But 100%, you want to make sure that anyone that's considering leaving money to your child, it's either putting it into a third-party trust or, I mean, again, you can use an ABLE account too, which we'll talk about. But there are some limits with ABLE that sometimes inheritance can't really go into ABLE because you can only put so much a year into an ABLE account. But, yeah, I mean, absolutely. It's not just for parents. It's for grandparents, for other relatives. I mean, talk to them about, are you planning to leave money to the disabled family member, and if so, what's the mechanism to do that? So back to pooled trust. So as I mentioned, I had just described, so you can set up someone for a pooled trust for someone over 65, but I sort of described the limitation with that with regard to the look-back period. As I mentioned before, a pooled trust has to be maintained by a nonprofit corporation. So you can't have a sibling be the trustee of a pooled trust. You have to have a nonprofit corporate trustee being the trustee of a pooled trust. The nice thing about pooled trust, you do not have to have a trust document drafted. There are standard form documents called joinder agreements that essentially join the individual to the pooled trust. They're governed by a master trust document that's already usually been approved by Social Security, approved by DHS, so you're not having to have anything drafted. They're just completing a joinder agreement that joins them to the pooled trust. The funds then, so all the funds in a pooled trust are pulled together for investment purposes, but they're all accounted for separately. So everybody sort of has their own account, but their money's being pulled with the rest of the pooled trust beneficiaries, and again, that's for investment purposes. At the beneficiary's death, this is sort of another key point. At the beneficiary's death, specifically the Achieva Family Trust pooled trust, when the beneficiary dies, any money left in the pooled account is retained by Achieva Family Trust and spent through our charitable residual program. I'll talk about that a little bit more in a couple slides, but I just sort of want to, again, call that to an example of why, again, you wouldn't want to necessarily rely on a pooled trust to take on an inheritance because, again, you do not have the ability to dictate where remainder funds go. In the case of a pooled trust, we're retaining that. We're spending it for charitable purposes, which for some people is great. That's what they like that about the pooled trust. But for other people, they're like, well, no, I want to leave it to my grandkids or my other kids. So, you know, it's not the best option for them. So when would you want to use a pooled trust versus a payback trust, for example? Usually I recommend with smaller sums of money. So say an individual inherits a life insurance policy outright, $30,000, or maybe gets a small personal injury settlement, $50,000. It may make sense to utilize a pooled trust over a payback trust because of the cost associated with establishing a payback trust. As I mentioned, you have to have an attorney draft that. That can run you anywhere from $2,500 to $5,000 to have that document drafted. And if we're only talking about a $30,000 settlement, I mean, that eats up quite a bit of the money just to have a document drafted. And again, the benefits of a payback trust over a pooled trust would be the potential for funds to be remaining to leave to family members after payback. With a small sum of money like $30,000, the chances of, first of all, that money not just being spent on the beneficiary during their lifetime are slim, but even if the beneficiary were to die suddenly, it's likely all would have to go pay back the state. So for some people, it's not worth having a document drafted just to have, the payback language in it, and they'd rather use a pooled trust because there's no cost associated with establishing it. So, yeah, so you can put third-party funds. I should just say this. You can put third-party funds into a first-party trust. It just really wouldn't make any sense to do so. You wouldn't want to put your funds into a payback trust or a pooled trust and subject it to either payback or pooled trust retention, whereas you cannot put first-party funds into a third-party trust. You just cannot do that, not legally. So, but again, it doesn't make sense to leave money to a pooled trust or a payback trust because you're subjecting it to those, again, the remainder funds either going to the state or being retained by the pooled trust, and also the age limitations, as I mentioned. So there are instances where third parties do fund our pooled trust, for example, Maybe during, the parent is still alive, they have a child who's maybe in their 20s, they put $500 a month in the pooled trust for that person to use. That's sort of an example when you might put third-party funds into a pooled trust, but it wouldn't be a good plan in terms of estate planning. You wouldn't want to leave $250,000 to the pooled trust when you could leave it to a third-party trust. So I mentioned the Charitable Residual Program. I bring this up not just, I had mentioned that any funds remaining in a pooled trust, at least here at Achieva Family Trust, when a beneficiary passes away, we use that money through our Charitable Residual Program. And essentially what we do is we give grants to people with disabilities. The only thing that's required is that the person is disabled and lives in the state of Pennsylvania. They don't already have to have a pooled trust with us. But if they have a need that isn't being met by their government benefit, or they're just not of means for various things, like, for example, camps, we do, iPads, we do vehicle modifications, we've done home modifications. And again, these are just needs that are not being met for whatever reason for an individual with a disability in Pennsylvania. They can apply for a charitable grant through our Charitable Residual Program. The applications are available at achievafamilytrust.org. They're reviewed quarterly. And Jen Sawyer is our residual coordinator. Her contact information is there. So I just bring this up just to say that if you have a family member, or if you have a client or someone that you know that has a need that isn't being met, they need some kind of adaptive equipment, a wheelchair, or whatever the case may be, they can apply for a grant through our website. And again, they don't have to have a trust with us. But it's just important to kind of know that. So if you know anyone or want to pass that information on, we've distributed over $4.5 million in charitable grants since the inception of the pooled trust. So again, it's something that we're very proud of, and it's really a nice feature of the pooled trust, and we're happy to be able to do that as opposed to giving the money back to the state. So a couple sort of fact, myth situations, I guess. You do not have to be, quote-unquote, rich, whatever that means, to have a third-party special needs trust. Achieva Family Trust will administer trust for as low as $500. That is not the case with most banks. They'll have minimums $250,000, sometimes $500,000 to be willing to administer a special needs trust. But nonprofits will do it for an awful lot less. So, you might look at your situation and think, oh, I don't even have enough money to do that. That's not the case at all. We will do them for as little as $500. And again, fact, implementation of a proper estate plan absolutely includes an attorney who has knowledge of special needs matters and planning. As I mentioned, we do have the attorney list on our website. We have an attorney in the room here who's on that list. So please feel free to get a copy of that off of Patty before you leave, or again, it is on our website, and it's a great start if you don't sort of know or you don't have an attorney in mind.
That's it. I wanted to ask you, have you mentioned the third-party trusts aren't funded until the individual has a lot of times that question comes up. When does it start?
Sure. So, there's kind of two options that you can have with a third-party trust. A lot of our third-party trusts are what we call testamentary trusts. They are a part of a last will and testament. The intent would be that it would not be funded until the passing of the grantor. So in a typical scheme, you have parents, mom and dad, they have wills, the money on the passing of the first spouse, the money goes to the second spouse, but then on the passing of the second spouse, it gets divided up according to the terms of the will. So a lot of our special needs trusts are just those. They're not actually funded now. Nothing's happening with them now. It's just sort of a document that exists. It's waiting for an event to occur, usually the second to die of spouses, and that is when the trust is funded. There is an opportunity to do what we call an inter vivos trust, so a trust that is funded during the life of the grantor. So mom and dad are still living. They've got this inter vivos trust. They want to start contributing to it now, whether as a savings tool, or perhaps they want the beneficiary to get used to working with a trust, working with a trustee. They may fund it while they're still living. So it's possible to do it both ways. And I would just say, to your point in the back, that can be a common sort of situation. Maybe you're funding a trust now, and everyone, as they're sort of funneling money to it, whether it's when they die or whether they're just wanting to put money into it through life. Sometimes people will establish that while they're living. It won't just be a part of the will. So it really just depends on what you're trying to get out of the situation. Again, I'd say the majority of our third-party trusts are testamentary. They're only funded at the death of the grantor, not during the life of the grantor.
What was the terminology that you used? You called it an intra?
an inter vivos trust, and again, that just sort of means that it's funded during the life of the grantor. So for mom and dad's life, they're still alive and they're funding it. The testamentary trust is not going to be funded until the death of the grantor.
You could set up something, say, for $500 right now, and then my husband and I then will receive with my daughter and him. But in the meantime, like for parents, say for a birthday, even wanted to put in $500, or a grandparent or somebody, like you could start to throw in little bits of money.
Yes, you could. We'll talk about ABLE accounts and why they might be a better vehicle for that. The reason is that once a trust is funded, it becomes a taxable entity. It gets its own EIN. It has to file a yearly tax return. If you're using a corporate trustee, fees will kick in. So there are some reasons, because we've seen that before, where a parent will fund an inter vivos trust for $10,000, and they think, okay, well, let's just get this going. And then they're just looking at it and they're like, well, we're not really using this, and it's having to pay for tax prep fees, and it's, it's being subject to investments, and fees are coming out of it, and they're kind of like, why did we do this? So
we almost wanted to start with $500 and let it sit there until we got.
Especially if you're not going to name a corporate trustee, for example, as a trustee, because if you're going to act as sort of the initial trustee, then you're not at least having to pay fees on it for a corporate trustee, for example. And it could just sit in a checking account and basically not be subject to any kind of investment income. Yes. Well, it's going to have an EIN number. That's the thing about it. So, again, when we're talking about sort of birthday gifts or just small sums of money funding, we'll talk about why ABLE might make more sense to do that. But, yes, what you're saying in theory can happen. Right. Right. Well, and it's not really penalties, but you might have some fees associated with administration that you can avoid. So, again, you can do inter vivos. I would say the best example of when someone does an inter vivos trust, you have two elderly parents, this comes up a lot, who have been taking care of their adult disabled child for their entire lives. They've been doing the finances, they've been paying the bills, they've been doing everything. They're getting elderly and they just can't do it anymore. They do not have it in them to do all of this work. Specifically a lot with our mental health beneficiaries, it can just be very time-consuming and very taxing to kind of be that person that stands between the person and their money, and they're just like, I want out of this. So what they may do is fund a special needs trust so that they can kind of get out of that role, but they also, while they're living, have an opportunity to see how a trust administration would work. So the beneficiary gets to interact with the trustee and see, and the parent gets to sit back and see, is this going to work? Do I like this trustee? Is this going to work for my child? So they kind of have the benefit of seeing how it would work out. Obviously, when you die, you're not going to know how that works out. So I would say that's sort of the primary example of when we see someone fund an inter vivos trust. Again, it's sort of specific to your situation. It's kind of hard to advise generally what to do because it really depends on everyone's individual situation. So that's something you want to talk to the attorney about for sure.
Question, do life insurance policies count towards assets of the disabled individual? Would it be the internal value or the death benefit?
So the question was about life insurance policies and if they're considered an asset to the individual. So depending on how you're looking at this, so if the individual with a disability is the beneficiary of a life insurance policy, then yes, when the person who dies, they die, and the beneficiary then receives the death benefit. That death benefit would be an asset. So if you have a life insurance policy that you leave your, say, disabled child as the beneficiary, you want to consider doing a third-party special needs trust, making the third-party special needs trust the beneficiary on the policy. Now, if the beneficiary, his or herself, has a life insurance policy that they've been paying into that has their children as beneficiaries, if the policy has a cash-out value, a cash value that you can call the insurance company and say, I want to cash this out for $10,000, it will be considered an asset for the beneficiary. So again, sort of two different situations, one where you've got the disabled individual as the beneficiary of a life insurance policy, and the second instance where they're the owner of the life insurance policy. If there is a cash-out value, it will be considered an asset in terms of eligibility for benefits. An example of when it wouldn't, an irrevocable burial account. We really recommend, people with disabilities set up an irrevocable burial account. It's irrevocable, which means it doesn't have a cash-out value. It can't, the beneficiary can't call the funeral home one day and say, never mind, give me the $10,000. It's irrevocable, and therefore it's not going to be counted as an asset for eligibility for Medicaid or SSI. So does that make sense? Did I answer the question, Greg? Okay. So I wanted to just...
Can I go back to your $500,000?
Yeah.
What does that cover? Like to start a fund?
Yes, I mean, really...
What would it cost to do, and I know it's going to vary depending on attorneys or whatever, but like the will to the special needs trust, like to get the thing started?
That's 100% going to vary based on the attorney. I mean,
because I feel like I need to be rich to do that. But
and I don't think that's necessarily true, Paula. I mean,
what was the question?
The question is how much does it cost to do one of these, basically. And, I mean, it's going to vary. Do you do an hourly rate or a flat rate?
I meet with the people first, and then we put together a plan, and I give them a flat rate based upon the plan that they develop. Like, you know, if it's super complex, I may charge by the hour. If it's pretty straightforward, I will give them a flat quote, and I will not exceed that quote under any circumstance. And it is going to vary extremely by what you want. It could be anywhere from a couple $1,000 to $10,000, depending upon what you're looking for.
That's my experience too. I mean, I've seen them be that much. I've seen them be. I mean, I would say that that's probably like a reasonable range that I've heard of. And again, that 500 doesn't have anything to sort of do with this. This is just establishing like sort of a minimum.
Procrastinating.
Well, and that I think that I mean, not only is it sort of a sensitive subject, but I mean, there are costs associated with it. But I mean, it really just, again, it's so important in order to get this plan right, because you do not want to have a situation where, you know, you've set your child up or your relative up and they're on these benefits and you know, everything is sort of going smoothly, and then that all gets interrupted by an unexpected inheritance or an unexpected situation. So, I mean, again, it's really, really important to do. I mean, a lot of attorneys will have sort of a consult with you to get the situation before you're being charged. So, I mean, certainly something to shop around. And
yeah, I mean, I'm more worried we could get killed in a car accident or something, and I got nothing left.
Nothing done. And that's exactly right. I mean, it's the kind of thing that it gets procrastinated, and then all of a sudden something comes up, and boom, you know, you never did that will that you got around to doing. So, you know, definitely recommend it's never too late to have that conversation with an attorney. All right, so we talked about special needs trust, so we'll just transition over to ABLE. I don't know how familiar everyone is with ABLE. I mean, it's like a relatively new concept. The ABLE Act, the Achieving a Better Life Experience Act, was signed into law in 2014 by President Obama. That was the federal legislation that was signed. Pennsylvania's ABLE program was not rolled out until April of 2017. So again, it's a fairly new program. I think everyone is still trying to figure out what's what with it in a lot of ways, but we'll try to sort of sort through the basics. So the ABLE Act was created under the Section 529 of the IRS Code. If you're familiar with 529 education plans, these are considered 529A accounts. So 529 education plans sort of are a vehicle to save for college. You can set up a 529 account, and the money in the 529 account can then only be spent on qualified education expenses. With an ABLE account or a 529A account, it works very similarly, except that the money in an ABLE account must be spent on qualified disability expenses. So, again, it's not like a regular 529 that's restricted to education expenses. The ABLE account is for qualified disability expenses. ABLE accounts are run through the PA Department of Treasury. We don't do them here at Achieva, but we do usually advise on ABLE accounts because we usually say they're sort of another tool in the toolbox for special needs planning and saving. So to sign up for an ABLE account or for more information directly from the source, paable.gov, and that's their phone number. But again, we do a lot of sort of counseling on ABLE here too, so I'll do the best to answer questions. Okay, so some of the main characteristics of an ABLE account, and I'll try to compare ABLE accounts to trusts as we go along so you can kind of see where they're different and why you might need one or the other or both. So the beneficiary is the account owner on an ABLE account. You can have authorized signers, so if you say you have a child and you're setting up an ABLE account. Now, obviously, if they're a minor, they can't own the account, but upon turning 18, the child will be the owner of the account. but parents can still act as signers. Compare that to a trust where the trust is the owner of the asset, and in order to access the trust funds, the beneficiary has to go through the trustee to do so. So there is a barrier between the beneficiary and the money in a trust situation. For ABLE, that barrier doesn't exist. So again, the beneficiary owns the account, and for some people, that is absolutely the reason they want an ABLE account. It allows for more flexibility. It allows for more direct access to the money. You don't have to go to a trustee to ask for a disbursement. You have a debit card, and it sort of functions like a bank account. For other beneficiaries, that is absolutely not a good thing about ABLE. If you have a beneficiary who isn't good with money or can't be trusted with money or is easily preyed on by other people for money, you might think twice about an ABLE account because, again, if there's the wherewithal there for the person to access the account, they have the access to spend it or give it away basically unchecked. So, again, it really depends on the circumstances of the beneficiary whether an ABLE account would work in your individual situation. Again, you can be a signer as a parent, so you have some access there, but you can't sort of restrict access by the beneficiary. The beneficiary of an ABLE account has to be disabled before the age of 26. So this is another sort of key difference with a special needs trust. You'll remember that the only age limitation for special needs trusts are with first-party trusts, and generally you can't establish them for someone over 65. However, with a special needs trust, it doesn't matter if they became disabled at 10, 20, 50. You can have a special needs trust. That is not the case with ABLE. You have to be considered disabled before the age of 26. ABLE sort of defines disability with two prongs. If you are eligible for SSI or SSD, you are automatically deemed disabled for ABLE. If you are not on those benefits, they basically require that you could provide a doctor's certification of a disability. You don't have to provide that certification upon setting up the account, but you're basically attesting that if ever questioned on it, you could provide documentation that the person was disabled before 26. For individuals, you know, with birth injuries or intellectual disabilities, this is usually not an issue. It's well established that they were disabled before 26. For our mental health beneficiaries, that's not so much the case because mental health can be onset later in life. It can be tougher to establish that it was onset before 26. So there's legislation where they want to move that age limit to 46. That has not happened yet. Right now, it's 26. So, I mean, again, imagine someone's 35, they get into a car accident and become permanently and physically disabled. They would not be eligible for an ABLE account unless they had some kind of pre-existing disability. So can be a little bit limiting in that way. Contributions into an ABLE account are limited to $15,000 a year from all sources. So, I mean, grandma, grandpa, mom, dad, brother, sister, they can all contribute to an ABLE account. The individual, his or herself, can contribute to the ABLE account, but only to the amount of $15,000 per year. So if grandma gives $15,000, that is the limit of the contribution for the year. Again, with special needs trusts, you do not have that limit. You can put as much or as little into a special needs trust. You're limited, again, if you're asking a bank to be a trustee, they're probably going to have a minimum that you can establish the trust with them. But, again, with a nonprofit like Achieva, we'll establish a trust for as little as $500, so you really don't have that limitation. SSI recipients can save up to $100,000 into an ABLE account without their SSI being affected. As soon as they reach that $100,000 mark, and that will obviously take several years at $15,000 a year, the SSI is suspended. The Medicaid that is tied to the SSI will continue. It's just the cash benefit will cease until the account is back under $100,000. So again, special needs trust, no limit as to how much you can put into a trust.
They can use those funds for whatever they want.
It has to be a qualified disability expense, which I think I'll probably define in the next slide. I think we'll define that in the next slide. It has to be a qualified disability expense. We'll talk about that in a second.
Aren't contributions tax advantage to the contributor?
Yes and no. I mean, you're allowed to contribute up to basically the gift tax limit. That's what the $15,000 is. So you can contribute up to $15,000 without the penalty because you won't get hit with any kind of gift tax. But in terms of tax advantages, the money in the ABLE account grows tax-free. So if you put $10,000 in and there are or 6 options in terms of investments. There's a straight interest-bearing checking account, and then I think there's about 5 investment options that range from conservative to more aggressive investing. So say you're aggressively investing $10,000, and in a couple years it grows to $15,000. There's no tax owed on that $5,000 gain. There also will be no tax owed if the money that comes out of the ABLE account is spent on qualified disability expenses. So, for example, comparing it back to an education 529 plan, if you use 529 funds for anything other than education, that money that comes out for that distribution would be considered income to the individual. Same with an ABLE account. If you're making a disbursement out of an ABLE account for something that isn't a qualified disability expense, that distribution would be considered income, and you would have to pay tax on it. But I think what we're going to find in the next slide is virtually anything can be considered a qualified disability expense. So I sort of challenge the IRS or Social Security to say that something isn't. I mean, there are so many things that be considered a qualified disability expense. You're likely not going to hit any kind of tax consequences for a distribution out of an ABLE account that isn't qualified. So, I mean, in terms of tax benefits, this is post-tax money. So, I mean, it's nothing like major, but there are some sort of tax incentives built in to the program. Correct. So, I mean, if you get your paycheck, exactly, it's not like a charitable contribution. So, I mean, you're not getting tax breaks in that way. So, I mean, you get your paycheck and you've already paid in, they've already taken taxes out of that. You can put whatever you want. It's not sort of a pre-tax situation. It's post-tax. It just comes out of the account without tax consequences. So, like, for example, with an IRA that's building money over time, when you take your required minimum distribution, you're having to pay income tax on it at that time. That's not the case with distributions out of an ABLE account, as long as they're a qualified disability expense, which, again, I hate to say out loud, but I don't know of any. I mean, there are very few things that I think aren't qualified disability expenses, at least according to how we've been seeing them administered. Remainder funds in an ABLE account, so they can be transferred to a disabled sibling of the individual owner, or if not, the money will go into the estate of the individual with the account. So the federal legislation allows states to institute a payback in their ABLE account. So in other words, just as we had described with the Payback Trust, money in the ABLE account could, in theory, be made to go back to medical assistance to pay for any medical assistance the beneficiary used during his lifetime. Pennsylvania at this time has not opted to do that. There is no payback provision, so Pennsylvania will allow, again, a transfer to a disabled sibling or the money just to go to the estate of the beneficiary. So I don't know if that will hold forever. I imagine not, given the state of the budget in the state, but at least for now, you don't have to worry about payback. A payback provision in the remainder funds. So qualified disability expenses, money can be spent, and these are just, again, some of the options: education, housing, transportation, employment training and support, assistive technology, health, prevention, wellness, financial management, legal fees, administrative services, funeral, burial. I mean, it's sort of endless. I mean, again, if you can make a connection to the disability and that somehow the individual with the disability is benefiting, I really think you can make the case that it's a qualified disability expense. Would I go and gamble it away in Las Vegas and try to make that case? Maybe. I don't know. I mean, gambling's fun for people. But, I mean, just as an example, that is something that may not fly, although I don't know that, but it may not.
So should the disabled person also have a will so that there's an estate for them?
In theory, I mean, a lot of times, the problem is a lot of times an individual with a disability, especially if they're on SSI or Medicaid, they're never going to accumulate assets really in their life to have to pass through a will, because again, you can only have $2,000. Now, you could have a vehicle, you could have a house, so it could be important for the disabled individual to pass those on. But yes, with the ABLE account, if the individual has a will, then the remaining funds in an ABLE account would pass according to the terms of the will. If there was no will, then according to the laws of intestacy. So yes, it could be important that an individual with a disability have a will, but again, if all they have is a third-party trust, when they pass away, the trust document will dictate where those funds go. Yeah, so it really, again, just depends on sort of what the assets of the beneficiary would be. If it's just that third-party trust that's available to them, then that's going to pass. Any money left over will pass according to the terms of that. But if the beneficiary owns a home, owns a car, owns an ABLE account, they may want to do their own will to determine where the funds go at their death. Something to note is sort of a really important piece to note about ABLE accounts. So we talked about previously that if an individual is on SSI and is receiving what we call in-kind support and maintenance, so payments from a family member or from a special needs trust to pay for rent, utilities, and food, that SSI could be reduced by up to a third. At this time, according to Social Security, payments out of an ABLE account for rent, utilities, and food will not count against the individual's eligibility for the full SSI amount. So let's take it back to our point originally. You talked about doing a lease situation to get the full amount of SSI. That's perfectly fine. Another option would be that if for an individual, say, that is receiving some kind of, that needs basically assistance out of, they cannot afford their living expenses with SSI. Again, we talked about 771. That's not a lot of money to pay for rent, utilities, and food. So where we were limited previously, where if we used a special needs trust to make up the difference for the rent, utilities, or food, that amount could be reduced. Now what we can do is, instead of using the special needs trust to pay for the rent, utilities, and food, they can use an ABLE account and not have that reduction. So what we've been kind of doing is, we've had people who have funded either pooled trust or third-party trust for a while and have been frustrated by that limitation that we can't pay for rent out of a trust. Now they fund an ABLE account for the individual, and he or she can use that money out of the ABLE account to pay for the rent, utilities, and food and not have the SSI reduced by a third. It really is, it's fairly counterintuitive because I don't think anyone can really explain why Social Security would treat an ABLE account completely different than a special needs trust or in-kind support and maintenance from a parent, but that is the reality at this point. So, I mean, I would say that, like I said, right now what we've been seeing is, you know, parents will put money into an ABLE account so that their child can use the money out of the ABLE account to pay for rent, and that way they don't get their reduction. They might have used a trust before, and now they're utilizing an ABLE account for that option. So if you've got a situation where someone is needing assistance with rent or they've been reduced because of the assistance, consider setting up an ABLE account for them because they can use that account to pay for their rent, utilities, and food without penalty on their SSI, for now at least. I mean, again, it seems fairly counterintuitive, but it is the rule right now.
So who do you set it up with?
Well, hold on one second. Let me grab her in the back. Yes, so we are comfortable as trustee right now. We are comfortable moving, and I'm sorry, the question was, can you move money from a special needs trust into an ABLE account? What we are doing now is we will move money from a third-party trust into an ABLE account or a pooled trust into an ABLE account. We like to see that language in a third-party trust. We'd like to see that the grantor of the third-party trust is telling us as trustee that that's something we're authorized to do, but we see little risk in doing that out of a third-party trust or a pooled trust. However, we're not doing that out of a payback trust at this point. The reason being that, again, money in the payback trust is subject to payback. If you're moving it out of the payback trust and putting it into an ABLE account, which currently isn't subject to payback, I think as trustee, we're a little concerned that that's a kind of a workaround that DHS may not be okay with.
So if the individual has, like, bonds and things like that, then we can move that into an ABLE account?
Yes, you can liquidate. So that's kind of common too. We see a lot with minors who have had bonds that have been given to them, or also sometimes people will put money into like an UTMA account or an UGMA account. Well, when the child turns 18, that becomes an asset to him or her, the bonds or the account. So those accounts, if you want to qualify for SSI or MA, will need to be liquidated, and putting them into an ABLE account would be a good option if it's under that 15. That's the only limitation. Sometimes people will have assets that are far higher than that, and that's when we usually recommend using a pooled trust.
So my son right now has Medicaid, but when he turns 18, he has to sort of reapply because
So, yes, there will be a look back, but again, at 18 or 21 or 26, I mean, again, and this is sort of going back to the benefits piece. Depending on the type of benefit, it may extend to 21 when the kid is still in school, and then obviously 26 is how long a child can stay on a parent's insurance. So, I mean, sometimes it depends on which age the person is looking to apply for Medicaid, but yes, the application will be on the child's own merits at that point, so no longer considering mom or dad's assets or income, just his or her own income. But if there are bonds or accounts and things like that, those are assets. But the benefit for an 18-year-old versus a 65-year-old is that you can put that money into a pooled trust or enable account, and it's not considered a transfer for less than fair market value. They can't give it away. Like, you can't just say, oh, just give it to mom, I'll put it in my savings account. You can't do that. That's still a transfer for less than fair market value. But at 18 or 21, the pooled trust or enable account is an option. That pooled trust restriction for transfers is really something for someone over 65, and the idea being is that they don't want someone over 65 going to apply for nursing care, and in order to qualify, basically they put their money into a pooled trust. They deem that a transfer for less than fair market value. But at 18 or 21, or whatever the case may be, putting money into a pooled trust or into an enable account is not a transfer for less than fair market value, and that's what you will need to do if he's going to qualify for MA, because he can't have more than $2,000 in assets. And again, money in a special needs trust is not counted as an asset for eligibility.
What's the minimum to open up an able account?
There is no minimum that I can tell. I mean, there's no sort of set amount. There are fees that come out. I think they're fairly minimal, like, I don't know, like $20 a month or something like that. I mean, there are some fees for administration, but there's no sort of minimum in terms of what you can put, just a max.
Open it up today.
Yes. Yes.
Start
funding it up to just $15,000 a year.
done. Is that each yearly fee
$60, okay. Okay, so if you're getting like paper statements or something, it might be a little more. Okay. I think I missed your question a long time ago.
Well, do you just open that at a bank or something, or with the state?
So you go to paable.gov, or it's through the Department of Treasury. They do their banking through Fifth Third Bank, which is a bank in Ohio. So you are sort of, once you sign up for an ABLE account, you're using who they bank with. Not all state ABLE accounts use the same bank. Pennsylvania uses that Fifth Third in Ohio. But it functions very much like a bank account because, again, you can have a debit card, you deposit it into the account like you would with a bank. There aren't many Fifth Third banks around here, so a lot of this stuff has to be done by mail if you want to deposit a check or whatever the case may be. But it's all done through the Department of Treasury.
When you set up a special needs trust through Testamentary, through a will, prior to that, who would you list as the beneficiary on an IRA or 401k
okay,
or life insurance policy?
Yeah,
so you had 3 children, you were listing them as equal beneficiaries, but one is disabled, and you don't want to get over a huge first-party loan.
Right. So, I mean, the question for the online people is about beneficiary designations. If you have a third-party trust, but you have some kind of account, like a bank account or a retirement account or a life insurance policy that will not become an estate asset and therefore will not pass through the will, what do you do? And again, you want to make sure your beneficiary designation reflects your estate plan. So this is very common that happens to individuals. They will go to the lengths to get a third-party trust drafted. They've got their will. They've got their third-party trust. Great. We're all set. Then they pass away and realize, oh, wait, the bulk of our assets were in a $1 million IRA that had a beneficiary designation. We didn't change the beneficiary designations, and now, therefore, you know, the bulk of the assets aren't even passing through the will or the special needs trust. They're actually just going according to the beneficiary designation, and oh, shoot. So is as important, and I mean an attorney that you're meeting with about setting up the will or the special needs trust should be talking to you about beneficiary designations, especially sort of in today's culture where IRAs, retirement accounts are really where most people have their assets. It's not maybe like it was 50 years ago where everybody's money was in a bank account or wrapped up in real estate. It's really wrapped up in these accounts that have designations. So you have to make sure that your beneficiary designations on your life insurance, your IRAs, your retirement accounts, whatever, reflects your estate plan. Because if you don't change those to make the trust the beneficiary and you still have just the disabled child as the beneficiary, the entire will and third-party trust in the will is not going to affect that. You've got to make that change.
So when you say it has to reflect the will, it's projected that a special needs trust would be established through the testamentary of the will. There's nothing really set up now.
Right.
So what's the beneficiary? A projected?
Well, and the insurance companies, the company that has the beneficiary designation probably will guide you specifically to what they want to see. Sometimes they do want to see an EIN, and you'll have to get that EIN in advance. Sometimes they have to have that. But I usually just recommend that, I mean, generally you could say the Joe Smith Special Needs Trust created under will of such and such, dated such and such. So, I mean, that you're really specifying which trust you're talking about, who created it, what document created it, and that usually is enough as the beneficiary designation. Like, correct, it doesn't exist yet, it's just in theory, but you need to refer to it in some way, and that's usually how you would do it. But like I said, I've seen situations where the insurance company actually will require an EIN, and then you have to just bite the bullet and get that. So if there's no activity, you're not having to do returns, but you have to get that EIN because they want to refer specifically to the trust by its tax identification. But yes, that is just very, very important in terms of estate planning because it comes up all of the time. I mean, I would say that it comes up for me at least once a month where we've got a special needs trust and everyone thought that everything was set up perfectly, and then boom, we forgot about this life insurance policy that names the beneficiary directly. And now we've got to set up a pooled trust or a payback trust to take on that money, but oh wait, sometimes the person's over 65 and then we can't. And now we've got to spend that money down in a month so that we can get it out of there. We can't just give it away. So I mean, it really does create a lot of confusion, and this is why I say, I mean, it's really not a good idea to leave an inheritance up to chance this way. First-party trusts are great tools. They have their place in all special needs plans, but not really in a future plan. I mean, they're sort of like the backup plan if all else fails. We don't want to just rely on that because, again, really the biggest limitation that I see is once someone's turned 65, your options become so minimal as to what you can do with regard to a first-party trust. So, again, we don't want to leave inheritances up to those risks. We want to do a third-party trust for that.
So, you mentioned that right now with an ABLE account, when the person dies, their estate will, or their money will go to the estate, but that can change.
I would imagine that the question is since right now there's not a payback for ABLE accounts, what if there ends up being one? I would imagine that anyone who established an ABLE account while this was the rule that they would be grandfathered in. That would be what I would imagine. That would only seem fair. So, and again, it may never happen. There may never be a payback. But, you know, a lot of the states that have ABLE programs have paybacks. I don't know why Pennsylvania at this point has elected not to have one. The legislation allows them to. Probably it's a good selling point, I would imagine, but they're going to just have to see how the program develops to see if that's feasible in the long term. But I imagine you would get grandfathered in if you set it up before the rule changed.
You mentioned briefly the 7 savings options for the CA account from conservative to aggressive.
Yeah.
And I don't know if I know you have a lot of other stuff still to tackle, but I just wondered, like, I'm clueless as to, you know, what do I want to set up? How do you decide that between the 7 savings options?
Yeah, I mean,
can you switch it if
you can switch it. I think they limit you to switching it like once every 6 months, so it's like you can't change it every month. I think there is a limit in a year to how many times you can switch it. But yeah, I mean, you could certainly switch it. I would just say that again, I mean, obviously the more aggressive your investments are, if you're investing like fourth quarter 2018, you just lost a lot of money. But if you're investing first quarter 2019, you probably just made a lot of money. So I mean, it's really just sort of it's just how much risk you want to take on. I mean, again, if you want to take on no risk, then just set it up in an interest-bearing checking account. Your returns are going to be minimal. You're going to get a couple cents on the dollar, but there's no risk involved. But if you're like, hey, this is like, we want to see if we can get this money to grow, and you want to invest it, you know, aggressively, you obviously, just like anything else with the stock market, you're taking your chances. So it's really, that is an definite individualized decision because you've got to factor in what other monies are available to the person. If this is all they have as their ABLE account, you may not want to invest it super aggressive.
I'm so ignorant to this whole ABLE account that I didn't realize that you could invest in.
Yeah.
And then it's not just going to be sitting there like you're going to.
You can earn. Yeah, and like I said, it earns tax-free, so you don't have to pay taxes on the investment income that it earns, but of course, you're always subjecting it to losses, too. So, well, as I said, PA-ABLE uses Fifth Third Bank, which is an Ohio bank. There aren't many branches around. There are some, but that's who they choose to use. Other states use different investment. That's a state decision.
And I do have ABLE brochures, but I'll put up
okay.
there with the attorneys as well. Really kind of capital checking.
Perfect. Oh no, how could I still have another ABLE slide? Okay. Okay, so a couple things that are new. If somehow you are seasoned in ABLE, there are some new changes to the ABLE account as of 2018. The annual limit increased from, when it first was rolled out, it was a $14,000 annual contribution limit. It's now $15,000. As I said, that's mirroring the gift tax exemptions, and imagine over time that will continue to change. This is a big one. We've got questions about this a lot. Transfers from a 529 college savings plan to an ABLE account. So for, say, for example, a child with autism, you, as a parent, you start saving for college when they're a baby, and you really have no way of knowing what they're going to be capable of in terms of college, and perhaps that as they become a teenager, it becomes clear that maybe college isn't really going to be the route, but you've been saving in this 529 education plan for all this time, and now you've got a bunch of money in an education plan with no education plans in place. So what they have allowed is you can now transfer money from a 529 education plan to an ABLE account without penalty. So in other words, that transfer won't be considered, it's a qualified disability expense, in other words. You won't get penalized for the transfer, but it is still subject to the $15,000 cap. So if you've got $100,000 in a college savings plan, it's going to take you a few years to get it moved over into the 529 plan. But again, that's really super important because it comes up all of the time where, you know, a kid maybe is like 15 or 16 now and the parents are realizing like probably college isn't the track for the child, but oh my God, we've been saving all this money for college all these years, now what do we do? You can transfer it to another child. Sometimes that's what people do. If you have a child that is college bound, that money can be spent on that person, but if you don't, you're kind of stuck. Now you can move it into an ABLE account just subject to those contribution limits. A couple other things just to sort of encourage, again, incentivizing to work. There's a tax credit that allows a retirement tax credit for owners who contribute their own funds to an ABLE account. And then the Able to Work program is allowing an individual who works to save more than the $15,000 a year. So again, for some people, that is going to be the source of funding an ABLE account. They work and they're just trying to put money into that account to save long term. Perhaps they're on MOD, Medical Assistance for Workers with Disabilities. They can only have $10,000 in assets, so at some point they might have to start contributing to an ABLE account to stay under the asset limit. They're allowed to contribute up to the federal poverty limit, which is currently almost $12,500. So they can contribute that above and beyond the $15,000 a year, so long as they're not participating in some kind of work-sponsored pension program. So again, that sort of might be a limited use for some, but for those who are working, that's a very, very nice option because it allows to save more in the ABLE account per year than that $15,000. Any other questions on, we are very close to running out of time. Any other questions on ABLE or special needs trust before I give the fastest talk about power of attorney and guardianship?
Can I ask one last thing? Can you grow your money in a PA-ABLE account, since my son's so young, and keep doing it and keep growing it, we'll use it at times or whatever, but then take that money and transfer it over into the special needs trust, a third-party special needs trust to protect it?
So here's, I guess, I've had that question asked of me, and I've sort of racked my brain imagining a situation in which you'd maybe want to do that. But my concern with that is that you've got the ABLE account and you've got contributions coming from a lot of different places. You might have first-party contributions, you might have third-party contributions. And so I sort of don't know how to reconcile that with the fact that if an individual has been contributing his own funds to ABLE, how you could then put that into a third-party trust, because sort of the characteristic of the funds, the owner of the funds, that doesn't really jive. But beyond that, I've really been trying to think of a circumstance in which you'd want to do that. I mean,
I'm thinking if they ever cap it, and we're nowhere near there. I've got $500 to put in.
Well, you would just start contributing.
$1,000, and you don't let me take over.
Right, and I would just recommend at that point, obviously, if you're approaching the $100,000 mark, I mean, you'd want to use that money first for day-to-day expenses first. And then second, if you're at the point where you have more money you want to contribute, then you just have to go to another, then you start contributing to the trust as opposed to the ABLE. But I would just recommend with the ABLE, I mean, you're just spending that to keep it under the cap. You're using it for day-to-day expenses. If there are no day-to-day expenses, then you're going to have to start saving in another sort of account. But again, for an SSI recipient, I doubt there will not be day-to-day expenses. I mean, it's going to be tough to even get to that point, again, just because you're so limited. SSI is such a small amount a month that it's likely you're going to be spending that money. Right, right. Any other questions on ABLE? Okay, so really quickly, so we kind of touched a little bit on guardianship and powers of attorney, and again, we could do an hour, we could probably do 2 hours on this topic. Lord knows I have, so we're not going to be able to cover this in great detail today. But just some things to consider, you know, is while you're doing your future plan, I mean, you're thinking about where to leave your assets when you pass away, but there are some other things that you need to sort of think about that might be more pressing, and that's decision-making for the individual with the disability. And actually, I should just say not just for the individual with a disability, for everybody. Everyone in the room should be considering having a power of attorney document. So let's just sort of hit powers of attorney first. So for someone without a disability, again, everyone should be thinking about having a power of attorney document. Basically what these documents do is they put someone in place, an agent, that is able to make financial or health care decisions for you in the event that you are unable to. Now, you know, for someone who does not have a disability or isn't compromised in any way, you are making your own decisions every day about your health and your wellness and your finances. But if you were to get into a car accident tomorrow and you were in a coma, or you became severely disabled and were no longer able to pay your bills, or you couldn't decide, should we do this surgery, should we use this life-saving technique, should we do this medication, should we try this experimental drug, whatever the case may be, if you couldn't make that decision, you would want to have someone in place that can. So a power of attorney essentially does that. There are 2 types, a healthcare and a financial. The healthcare power of attorney puts someone in your place to make healthcare decisions for you in the event that you cannot make them. The Allegheny County Bar Association has a really nice sort of living will document that people always ask, oh, I need an attorney for this. I would say not necessarily for the healthcare. It sort of runs you through you sort of check, would I want tube feeding? If I were in some kind of end-stage medical condition with no hope for recovery, would I want tube feeding? Would I want life support? Do I want to be an organ donor? Sort of those types of things. You can go through and mark those yourself and sign it and have it notarized, and it's as good as being able to use. Give it to your doctor. Give it to anyone that's providing medical care for you. But a financial power of attorney is not so much a do-it-yourself endeavor. They can be really tailored to how much authority and power you want to give your agent. So I definitely recommend, again, when you're doing powers of attorney, definitely with the financial, talk to an attorney about that, because you'll really need to go through the document and decide, number one, who is appropriate to put in your place to make financial decisions, because it really is, it's a lot of authority you're giving someone else. If you can't make decisions, they can basically act in your place on anything financial. So you want to make sure you have the appropriate person in that role. And then you also want to be able to define the circumstances in which the power of attorney would be used, what kind of powers your agent would have. So I do not recommend doing a financial power of attorney yourself. Right, Paula? Okay. All right. Don't ask me what it costs, because I don't know. Ask Paula afterwards. I don't know. But specifically for someone with a disability, this can be tricky, because when a child turns 18, when anyone turns 18, you essentially are of age to make your own decisions if you have capacity to do so. So it can be very, very confounding for parents who for 18 years have made every decision for their child, and now at 18 they go to call the bank or they go to call the doctor and they want to talk, and the bank refuses to talk to them. The doctor refuses to talk to them. The child is 18 and can make decisions.
Because, you know, we, as a course coordinator, we run into this a lot where, you know, the individual, they turn 18, you know, families are seeking the guardianship, but, you know, that can take some time. And now mom and dad can't talk to the healthcare professionals, they can't talk to social people
can't
discuss this stuff on the phone.
So, and again, unfortunately, this isn't like a black or white answer. I mean, it really is, it's subjective. I mean, it's the attorney that you're working with has to make a subjective decision based upon what he or she is encountering to determine whether he believes that the person has the capacity to sign the document.
Can a letter be written by like medical professionals?
That can certainly help. I mean, again, capacity could be a fluctuating state, especially, again, for our mental health beneficiaries. They may go in and out of quote-unquote capacity. So there are circumstances where it's just not going to be that clear because, again, today, my background before special needs was just sort of in run-of-the-mill estate planning and administration. And someone would bring in 95-year-old mom who today didn't know where she was, who the president was, what the day was, what the date was, but the next week she comes in and she's lucid as can be. It really, really can be a tough decision for an attorney. I mean, we used to have sort of questions and tests, and you kind of just try to make it do you have something of like sort of that nature?
I do have a lot of questions, mostly about how the individual communicates, and I go through a checklist of that. But then I also do like to bring in a psychologist or a psychiatrist who has been working with the individual or evaluate them if they don't have somebody on it. And in terms of the time period, if you're worried like the person going to need guardianship, but you said it takes some time, it takes a few months, maybe 3 months, depending on the court schedule. And if a circumstance should arise that is emergency, you can get an emergency hearing on a decision if there's a question. So it's not the end of the world if it's not established and in place, the day after their 18th birthday. But there are tools. I make the assessments myself when I can, or I defer to psychiatric and medical professionals, and I have a list of questions for them that they have to answer to help me decide if this person has legal capacity.
Yeah, and I think, for some individuals it's going to be obvious that if you've got someone who's nonverbal, or, there are some situations where it's absolutely going to be obvious that they cannot sign a power of attorney or enter into a contract, and that's where sort of guardianship will absolutely come into play. I think it's just these tricky situations where it's not so obvious. The courts definitely lean towards power of attorney. They're far less restrictive. They're easy to be changed. You want to do a power of attorney absolutely when you can because it's going to cost you a lot less. It's going to take less time. And, again, it's more flexible. Guardianship is sort of you're basically taking someone and replacing their ability to make decisions with someone else completely. It can be for their finances and their day-to-day living. So a court really is going to defer to the ability to do a power of attorney because they don't want to take someone's, rights away to make their own decisions. But there obviously are situations where someone cannot make their own decisions, financial or health care, and a guardianship is going to be necessary.
I just, from my own personal experience, even my son is nonverbal, I recommend you start before they're 18. Because I started like last March and I just had my hearing on Friday. It's like a lot of dragging the feet even when you're getting it all set up and they have to go seek out all that information just to save yourself some aggravation because my son's nonverbal and once he hit 18 in October, they would refuse to give me the information. And then you say, well, he can't talk to you, he's nonverbal. It just saves you a lot of grief because if it's already in place and, right when you turn 18 it kicks in and you have a hearing.
Yeah, it absolutely, guardianship absolutely takes time and it costs money. So, if you're concerned about that, at 16, 17, you might want to start thinking about at least getting your ducks in a row. But again, the process isn't going to actually be able to, the hearing can't happen until the child's 18, but you can certainly start getting your paperwork together to be sure.
They, they have to get all that information, from the doctors and stuff like that. It took a lot of time.
Yep.
And it's a lot of money.
A lot of money.
$2,500
yeah.
between court fees and attorney. But to me, for someone who their child can't make it like a nonverbal, I have it.
There's really no choice.
Definitely you'll change my life for the better.
Absolutely. And so, and again, so that's sort of, and that's just why I bring it kind of up in the context of this presentation because, again, we've sort of been focusing on eligibility and benefits, and that's all extremely important, but again, I encounter parents all the time that it is incredibly frustrating. And again, you might have even, this is also very common where The child turns 18, and then, you're used to the pediatrician, the doctor. Well, they keep talking to you well beyond 18, and now the kid's like 30, and you've never even had to give it any thought, and for some reason you need to call Social Security, and you're like, are you kidding me? Like, I've been, like, talking to doctors, I've been doing all of this stuff, but, I mean, the reality is when they turn 18, these Social Security and Medicaid doctors, they reserve the right to not include you in decision-making unless you have some authority to do so.
So once again, my ignorance is missed. My son's 9, so that means he's nonverbal and will never work, will never do any of those things. So it's starting around 16. I need to start all of that stuff.
I would start thinking about it.
Even like, I started, he just turned 18 in October. I started last March. Yeah. And I had my meeting with his, well, we started, seeking out this stuff. And then last July I had my meeting. And then, it took all that time to get all that information. And then I just had my hearing Friday. And you will have to go through a court hearing in order to get legal.
A judge has to,
$2,500, which is great. With, I thought that was able.
You can pay for that out of an ABLE account.
And it's obvious, like you mentioned, that she's intellectually challenged a little bit, but the diagnosis is
Mm-hmm.
It's verbal, but the school can prove that, show an ID or something. Why is it so expensive? Do I even need a lawyer? One question. And another question that was mentioned, you start the due diligence preparation yourself, find the document in advance, but when you call the court and ask them, can we have a hearing, and they can tell us she's not 18 yet, call us later, or can they, before she's 18, can they put us on a waiting list so that it is as close to her 18?
So it's, and again, it's because, guardianship, I mean, again, it's not sort of as simple as calling the court. I mean, I do not recommend trying to navigate guardianship on your own because, again, it requires sort of building a case to demonstrate that the person is incapacitated. And if there is even a question as to that, that's really going to be where building the case becomes more challenging. And if there is question that the person could have capacity, before I'd even think about guardianship, I'd want to talk to an attorney, can we do a power of attorney here? Because if the person can be judged to have capacity to sign a power of attorney, there's no need to go to get a guardianship. So the first question is if there's any sense that there could be capacity there, you want to talk to an attorney about just doing the power of attorney. That is going to cost you so much less, and it's not going to take any time at all. Those are signed, they can be signed same day. So if there's any question about capacity, you need to pursue the power of attorney route first. If there's absolutely no way that the individual could sign a power of attorney, cannot enter into a contract, and you know that guardianship is likely going to be the route you have to take, I would still recommend talking to an attorney probably in the year or so leading up to he or she turning 18, because then you can start finding out what is this going to cost, what kind of documentation do we have to come up with, what kind of expert testimony do we need to prove capacity, and then that way you're not kind of starting that process when they turn 18, you've sort of underway with gathering that information. But I think you sort of indicated that the person may have capacity, or you're not sure.
Well, if the person is verbal, but if the level of math and reading is low, if there is a challenge,
You want to talk about power of attorney first. Well, when I'm in that situation, I mean, again, if you're going to try to get guardianship, a judge has to find that this person absolutely cannot make his or her own decisions. And a judge is not going to take that right away if he or she believes that capacity is present. So I would start with talking to an attorney about should we do a power of attorney here as opposed to guardianship, because you could still be appointed as the agent under power of attorney and make health care and financial decisions just the same. But if an attorney says, I'm not comfortable doing a power of attorney here, I do not believe that your child has capacity to enter into a contract, we need to pursue the guardianship route. At that point, you can decide, well, do I want a second opinion and talk to another attorney, or do we just start the guardianship process, gathering the information, lining up experts and things of that nature? But if there's any question about capacity, and I'm not asking you to make that decision, that's why you talk to an attorney, the first route is going to be to try to do a power of attorney. Again, it's less expensive, it's less restrictive, it's less time-consuming. The guardianship is only going to come into play if the person absolutely does not have capacity.
Is there any diagnosis that they just consider not able to make?
Well, I mean, again, I think that if you've got in a nonverbal situation and I mean, the functioning level is quite low, I mean, I think that that's pretty obvious. But like autism, for example, or even some kind of, intellectual disabilities where the individual is higher functioning, you might get away with doing a power of attorney and prefer that. And that's the problem, because it really comes down to what an attorney is willing to do, and again, it's subjective. It really is subjective. Correct. Correct. Yes.
And you would only need guardianship
if the person's deemed, if the person is deemed incapacitated, then you have a hearing to basically make that a formal determination. Someone is then appointed guardian and is able to make decisions on that person's behalf.
Question on if the parents are guardian or power of attorney and then we pass, do we name a guardian?
So the question is how do you sort of appoint successor guardians and powers of attorney? The power of attorney document usually at least accounts for one successor agent. So maybe mom and dad are co-agents, and then if mom and dad are unable or unwilling to act, then sibling is a successor agent, and then if sibling, then another sibling. You can work that all into a power of attorney document. Guardianship, again, as part of your will, you can make a recommendation and say, well, if mom and dad are not available to be guardians, we'd like sister, and if not sister, then brother. But the court still has to go through a formal hearing to make that appointment, because when you make the document, sister might be a good candidate, but when it comes time to do the hearing, for whatever reason, sister may be a bad candidate. So the judge has to formalize that. You sort of can't set that up in advance, but you can make a recommendation, and your recommendation will be given a lot of credence, but it still has to be evaluated through the court.
I don't want to take up too much more time. I just wanted to point out, you keep saying, the attorney, for power of attorney, the attorney will make their subjective determination. There's another very important person in that process, and that's the notary, who signs the power of attorney, and they have to be convinced that the person who's giving the power of attorney has the capacity to do so as well.
That is true. And that's why, and again, an attorney is probably going to err on the side of caution, but again, it's just the point being that guardianship sort of it's not the easiest route, and judges just don't go and give guardianships out. I mean, there has to really be a demonstrated incapacity. So you're going to err on the side of using powers of attorney, but where they're not possible, then you do guardianship.
In other words, if your child doesn't have siblings, but for example, the child has aunts and uncles, but you don't like that, you don't want to put that on them. You don't want them to be the trustees if there is a third-party trust. So in this case, we need guardianship.
No, and let's talk privately after this in 2 minutes, because we just confused two very important issues, so I want to talk with you privately. Go ahead.
I know that working on how to speak with families, they sometimes reach out to law students to help with this, and I know it's low to no cost. I know it can be really expensive. That's always.
Yeah, good point, and I'm going to repeat this for if anyone is still hanging out there online. She'd mentioned that Pitt Law, they have legal clinics, and I work with them. Martha Mannix is the director of that clinic, and they will basically, under her supervision, her students will create wills, powers of attorney, and special needs trusts. That can be a really nice option because they, especially when they're naming Achieva, they always send the document to me for review. So, I mean, they're being supervised by Martha, then I'm getting sort of the double check. So that can be a nice option. You kind of do have to demonstrate some financial hardship. They won't just do that for anyone, but we have utilized the Pitt Legal Clinic before when people were, absolutely could not afford any kind of legal assistance. They've done it through that program.
I just want to mention, Jackie, too, if you subscribe to our newsletter, usually once a year we do have a free legal clinic. So we usually have the fall and bring an attorney and a free 30-minute consultation on special needs trust. And that's always been very successful. We may do one on guardianship and power of attorney, maybe this year, maybe early next year. So just pay attention to our newsletter because we do, that's what we circulate the invitation.
Yeah, that's a really good point, a really nice option. Paula's participated in that before, and again, you get to come to our office, you get a free 30-minute legal consultation about any kind of special needs planning matters that you have, and then obviously have the option to follow up for a fee with the attorney at a later date, but it might give you some things to think about.
Relation to what you said, you don't have siblings or
Yeah, so let's the three of us have this conversation right now privately, and I need.
Are there any other questions? So thank you all for coming. And
thank you.
Just as a reminder before you leave, there's an attorney who's up here. There's information on EAA and our Charitable program. So, thank you. So